Hey folks, good morning. My name is Greg McLawsen. I'm the Affidavit of Support lawyer. I help green card holders enforce rights under the USCIS Form I-864 in federal court. I wanted to talk today about a decision where an affidavit of support claimant actually lost on appeal, but this is a rare case where I actually think that was the correct result in this situation. Shout out to attorney Deshaun Johnson from California, who had called me up to consult about a completely unrelated case and mentioned this Court of Appeals case, which I had missed and not seen until he brought to my attention. So this is the marriage of Adeyiyi case, and here's basically what happened. We had a non-citizen, a sponsored immigrant from Nigeria, who was in the process of getting divorced and went to the family law court in California and asked the family law judge to enforce the affidavit of support. Now, California is one of the states, along with Texas and North Carolina, that says you can enforce the affidavit of support in family law courts. That is actually the approach most states take. Washington State, where I live, in beautiful Seattle, Washington, is an exception. And in Washington State, you cannot necessarily enforce the affidavit of support in divorce, but you can in California. So this claimant went to the family court judge and said, I'm a relatively recent immigrant. The respondent in this case signed an affidavit of support, and I want you, trial court judge, to enforce my rights under the affidavit of support. That's all well and good. What happened, though, was with the affidavit of support, the federal statute defines a sponsor's obligation in relation to the federal poverty guidelines. It says the sponsor has to provide income to maintain the immigrant at 125% of the poverty guideline. Elsewhere, in a different part of federal law, the law explains when a sponsor's obligation ends, and it lists some events that include when a green card holder has 10 years of work history. So the claimant in this case, the person with rights under the affidavit of support, went to the family law court and argued, I don't have 10 years of work history yet. And that was true. I don't have 10 years of work history yet. And so I want an order requiring the respondent, the guy who signed the affidavit of support, to provide support equivalent to 125% of the poverty line. Sorry for all the numbers, guys. It's just the way the statute works. I want you to make him pay me this amount. It's roughly $1,500 per month back when this case was decided, because I don't have 40 quarters of work yet. I don't have 10 years of work history. And the trial court agreed. The trial court said, I can see that you don't have 10 years of work history. This guy unquestionably signed the affidavit of support. So I am entering an order requiring him to pay that amount of money until you hit 10 years of work history. So he appealed, and he said, Court of Appeals, the trial court got it wrong, because I, as the sponsor, yes, I have an obligation to the sponsored immigrant, but the nature of that obligation is to restore that person, the sponsored immigrant, to 125% of the poverty guideline. That means if she's already earning that amount of money, I don't have an obligation to provide support. And the Court of Appeals agreed. Let's jump into the decision here just a little bit. Oops. Okay, so this is marriage of Adeyiyi, and you can see that down at the lower court, the trial court level, what happened was the trial court got a little bit confused by these terminating events. Remember, I mentioned there are listed events under federal law. They actually come up in the statute in part and in the regulations in part, but don't worry about that. Federal law basically says 5 events that terminate the affidavit of support. And one of them is this 10 years of work history, 40 quarters of work. So the trial court basically said, the sponsor has an obligation to provide support until that 10 years of work history has happened. And the sponsor just has to pay 125% of the poverty guideline until the green card holder has 10 years of work history. On appeal, that's the first highlighted portion here, the respondent, the guy who signed the affidavit of support, says, look, I don't have an obligation to provide support until if the green card holder already has income of her own. Trial court had disagreed with that, but the Court of Appeals correctly said, yes, the sponsor is right in this case. And all we've got to do is look at the text of the statute itself. That's the highlighted portion here. The statute, federal law, says a sponsor agrees to provide support to maintain the sponsored immigrant at an annual income not less than 125% of the poverty line. So that defines a sponsor's obligation. Well, how do we know if a sponsor has breached the contract and violated his duty? Well, his duty is to make sure that the non-citizen, the sponsored alien, has income not less than the poverty guideline. So if her income is at that level, the sponsor doesn't have to do anything. And that is correct. The only time a sponsor has to jump in and provide support is if the sponsored immigrant's income falls below that benchmark level. Now, the Court of Appeals goes on to cite a bunch of cases that say exactly what the statute says and clarifies that when it comes to these terminating events, that's where we get this language about 40 quarters of work. Those define when the contract terminates, when it is no longer enforceable. So after the non-citizen can be credited with 40 quarters of work, contract is terminated, sponsor's obligation is done. But while the contract is still enforceable, as it was in the I-864 case, the sponsor's obligation is only to take that green card holder's income back up to 125% of the poverty guideline. And if she's there by herself, the sponsor doesn't have to do anything. So this was unquestionably the correct result in the case. I actually haven't seen a situation where the trial court got it wrong in this particular way before, because as the Court of Appeals points out, the statute's pretty clear on this. But Court of Appeals got it right. It got remanded back to the trial court, and presumably the trial court will do what federal courts and state courts do in all of the tons of cases I've done in this arena, which is look at the green card holder's income, compare that to 125% of the poverty guideline, and then require the sponsor to pay the difference. That's how these cases are supposed to work out. As a quick aside, the time this gets complicated from an enforcement standpoint, and maybe this is what the trial court was trying to work around, is that math that I just described is relatively easy when it comes to the past. When it comes to the future, the courts are in kind of a tough situation because they can't know what the green card holder's income is going to be in the future. So what they have to do is craft a remedy, which is usually to tell the sponsor, we don't know what this person's income is going to be next month. So you guys are going to have to talk. The green card holder is going to have to tell you what her income is, and then you are going to have to cut a check to make up the difference. But we don't know what the income is now, so we can't tell you a specific number of what you are owed, or what you're responsible to pay in the future. But that's just something that happens in all of these cases. Hope that's helpful. Take care, everyone. Feel free to drop into the comments with a question.